Hello, families, and welcome to another episode of Thriving Special Families. I'm your host, Crystal Sanford, your autism and IEP advocate, serving families in California and across the U.S. I'm happy to be here today with our special guest, Thomas, Thomas Murray from San Diego, and he will be sharing with us about limited conservatorship. Hi, Thomas.
Hello. Hi, it's nice to be here. Thank you.
So glad to have you, and thanks for your time. I know it's a busy time for you, and I really appreciate you being here.
My pleasure.
Awesome. So families, again, this is Thriving Special Families, your show for insight, humor, and hope along your special needs parenting journey. I'm an advocate, but I'm also a parent and a speech pathologist, and I love providing quality information to fellow families. So if you're joining us in the podcast, welcome. I'm so glad to have you here with us. If you're joining us live, that's awesome as well. Feel free to leave your questions and comments in the comment section, and we'll do our best to answer those along the way. And lastly, always know that the information that is shared is for your informational purposes only. If you are in need of medical or legal advice, please do contact a professional in that area. So let's get started with Thomas. Again, Thomas Murray is our resident expert on conservatorship. And Thomas was born in New York City, and he grew up in New Jersey until moving to San Diego after his first year of college stalled out. After some life experiences, he continued college and then finished his paralegal school and then law school. After working in a few law offices during and after law school, Thomas created his own business, Murray Law. In the image of how he likes things done, Thomas is upfront with people and he treats them fairly. He believes that they will tell friends about you, and with that business model, it's not even been necessary to advertise, as there have been plenty of people needing his assistance. And I'm really glad about you and learning about you. We actually met in a neighborhood group, and we're business owners in the same neighborhood. So really glad to have you here. I feel like the value of story is so important. So can you share a little bit more about what led you to become an attorney? I know that whole stalling out in college, I get that. That happened to me too. So let's hear a little bit more about your story, Thomas.
Sure. Well, my father was an attorney. He did criminal law, and I saw him in his practice, and he was really unhappy. So I thought that I wanted to be an attorney because of the options it gives you, and you can help people. But I knew I didn't want to do criminal law. So during law school, I did an internship with a local attorney, and it was much more in line with what I thought I might want to do with my life. People coming and needing help, and me being able to provide a solution and assistance. And I deal with, instead of dealing with people that may or may not have committed crimes, I deal with families that have children and life concerns that I get to assist them with. So that initial internship turned into my first part-time position. I was working at a local bar, and I, for years, made more money as a security or a bouncer at the bar than I did as an attorney for a while. But eventually my patience paid off, and in forming my own firm, I get to do things my way, and it seems like I'm happier, and so are my clients. So.
Oh, that's awesome. Wow. A similar situation. Same thing happened to me. I learned about the field of speech pathology and did an internship, got a part-time job, and ended up becoming a speech pathologist. So kind of similar situation.
Mm-hmm. I remember studying for the bar exam at the subway across the street from my job.
Wow.
I haven't had Subway since.
I'm sure. A lot of Subway.
Yep.
Yeah. So, Thomas, again, so glad to have you here. I know one of your specialties is helping parents navigate limited conservatorship. And so that is our primary topic will be today. Can you help us explain for those novices like myself, what exactly is limited conservatorship?
Sure, absolutely. I think a good place to start is with conservatorship itself and what that is. So part of what I do is draft estate planning documents to prepare for unforeseen circumstances. One of those would be death, so we would draft a will or a trust. Another circumstance would be incapacity. So if someone is in a car accident or is diagnosed with or suffers from sort of illness where they can no longer knowingly make decisions for themselves, we draft power of attorney documents, and that allows someone else to make decisions for that person. So if I filled out a power of attorney document, I would nominate someone I trust to be able to step in and make decisions for me, manage money, approve medical procedures, that sort of thing, if I wasn't able to do it for myself. Now, not everyone takes these steps ahead of time to draft a power of attorney document. So if I were to need this kind of help, if I was in a car accident and I wasn't able to approve medical procedures, we'd have to go to court, and someone would have to petition to be my conservator to be able to approve medical procedures, handle my money if I couldn't do it for myself. So a conservatorship is really a court-ordered power of attorney, really.
Okay.
So a limited conservatorship is a conservatorship geared toward the developmentally disabled. Generally, it works with regional center clients or those who are eligible for regional center care before their 18th birthday. So there's conservatorship is sort of the big category. Limited conservatorships is a smaller section under that umbrella, which deals with developmental disabilities.
All right, that's perfect because that's our audience. And that's me, so we all are parenting children with unique needs. And as those children get older, I think parents hopefully start realizing that, things shift at the age of majority. When a child turns 18, they legally have the right to make all their decisions, including like in their IEPs, where I help families navigate the IEP process. But
Right.
when a child turns 18, it's their signature that's required, right? And
Right.
so this is really powerful for parents to learn about ahead of time so that they can help make some decisions proactively, and so they don't end up, having to really struggle and kind of run around at the last minute. So how would that differ for a parent looking to support their child with unique needs? Could a parent obtain power of attorney for their child, or is it only limited conservatorship?
Generally, it depends on the child. Generally, if the child is, first of all, of the age of majority, as you mentioned, they must be 18 to enter a legal contract. And a power of attorney is basically a legal contract. You're signing over the rights to make decisions on your behalf to someone else. Okay. So you have to be of the age of majority for that. And then you also must have the ability to understand what you're doing. You need to be able to knowingly understand that you are giving that authority to someone else. Mm-hmm. So if the child is underage, then no, you can't do a power of attorney, basically. And if they are, 19 years old, let's say, or 18, and they wanted to do a power of attorney, I would recommend that a doctor be consulted and some sort of letter be written. Does this child have, or does this person have the understanding and the mental capacity to draft such a document?
Okay, so sounding like if there's any concern potentially, it looks like limited conservatorship is the better way to go for our families. Yes,
I would say so.
Mm-hmm. And can you explain the different powers of limited conservatorship? Because I think we talked about that before.
Yes, absolutely. So there's 7, and on my good days, I know them all off the top of my head, but I'm on camera, so I'm not going to mess that up. The first is the right to fix the residence or dwelling of the individual. So where do they live? If it's at home with the family, great. If it's at a facility, that's something the limited conservator would decide. Number 2 would be access to confidential records. Some private documents or sensitive documents, the conservator would have the right to, limited conservator would have the right to manage those confidential records or documents. Then there's the right to contract, cell phone agreement, TV contract, borrowing money, those sort of things. Sometimes when someone doesn't have mental capacity, they could be taken advantage of. And it's very important in that instance to have a limited conservator who can say yes or no to these kind of things, just to protect certain individuals. the right to withdraw or consent to medical procedures is another one. And then we have education decisions, entering school or vocational programs or anything like that. And then the next two are the ones, now any number of these 7 can be approved or disapproved, or you can request all 7 or just a few. The next two, the last 2, are the ones that are really I see the most flexibility with. Normally the first 5 I mentioned are standard. Most people request that from the court, that authority. The next is social and sexual contact. So who are you dating? Who are you spending time with? Limited conservators can request the ability to make those decisions for their children. And then the last one is marriage. It goes a little bit beyond, social and sexual contact. Do you have the right to enter a marital contract by yourself, or are you looking to your conservator, your limited conservator, to assist you with that? So that's the 7 powers there, and that is really the main difference, I would say, other than the developmental disability kind of heading on it. A standard conservatorship or a probate conservatorship or a general conservatorship, those are all the same thing. It's just basically not a limited conservatorship. There is no list of powers as there is with a limited conservatorship.
Well, this is great information. I feel as though may not know that they can just have a certain level of, supervisory support over their child, but depending on the child, they can be released to make some of their decisions themselves. So that can be a nice balance depending on the child.
Absolutely. It's really nice to see a child be under conservatorship for a couple of years and then be high functioning and thrive and be able to go to court and get some of this decision making back for themselves, which is great. It's one of my highlights is when I get to do something like that.
That's awesome.
One other difference I wanted to point out again was the regional center involvement. When a petition for limited conservatorship comes before the San Diego court, one of the requirements is that the regional center caseworker file a report saying whether or not they're in favor of the conservatorship, if they have any concerns. So the regional center in many cases is an advocate for the proposed limited conservatee. In a general conservatorship or a probate conservatorship, there is no regional center involvement. So you would have either a court-appointed attorney or a court investigator or both sometimes. So that's another main difference between the two.
Wow, very interesting. And I know I've shared this with families before that once a child turns 18, that's really when you start to see more involvement by the regional center and apparently in this capacity as well. So, they offer so many supports regarding, life coaching and helping with finding places of living and so many job coaching, transportation. So they really play a larger role for our young adults once they turn 18 and apparently in this area as well.
Absolutely. Transportation, like you said, is huge. Day programs or socialization. I see them doing wonderful things for people in those areas.
Yeah, that's great. And for families who are just joining us, welcome again to another episode of Thriving Special Families, sponsored by Sanford Autism Consulting. Today, our topic is limited conservatorship, what every special needs family should know. And our wonderful special guest is Thomas Murray. So thanks again, Thomas, for kind of helping us to define better what a limited conservatorship is. Now, my next question is it ever too soon to be investigating this? What would be, in your eyes, best case scenario for a parent looking to investigate limited conservatorship?
Great question. You touched on it before, which is the age of majority. Typically parents have decision-making abilities, binding legal making decisions or capabilities for their children until the child's 18. But it's generally not a good idea to wait until the child's 18 to petition for conservatorship because it can take a while. Sometimes there's delays any number of things. There could be a notice defect, someone that should have gotten notice of the petition didn't, or the regional center report wasn't filed. The hearing can be delayed. And the way things are now with COVID and the court is understaffed, continuance of a hearing can cost 3 to 4 months. And if decisions need to be made, there's no one with legal authority. So to answer your question, I would say, generally 6 months before the child turns 18 is a good window. Get the petition in, make sure it's approved before the child's 18, and the letters, which is what the court signs, it's the order and then the letters of conservatorship, show the authority. And those letters can be dated to take effect on the child's actual 18th birthday. So there's no gap of time where the parents can help their child.
That's really good to know. So parents are thinking, oh, well, I don't want to start too early. Well, what you're saying is that those things can be put in effect. They can be documented kind of proactively so that they're in effect when the child does turn 18.
Right. Yep. And don't hold me to 6 months. If you want to do it a year before, I don't see the harm, because I've seen these be delayed. So I've never seen the court say, well, that's too early, you're going to have to wait. I think that the court is wanting to help people and reasonable, and would take the orders early and just make it, like I said, take place, effect on the child's 18th birthday.
Awesome. Now, what happens, Thomas, if by chance there's families that just, they weren't aware of this information? Maybe they're just watching us today and their child, is turning 18 tomorrow or next week. What are the options for that family whose child is or is about to turn 18 very soon?
Well, hopefully there probably will be a gap then. I mean, if you file today, you get a hearing probably in 2 or 3 months. It would be my guess. Mm-hmm. And so there may be a small gap. If there are what the court likes to call exigent circumstances or an emergency, you can file an ex parte hearing or a rushed hearing for temporary conservatorship. And the court does grant those if there's good reason. If an urgent decision needs to be made, or there's a medical risk and only a conservator can approve it, then those are good examples of, maybe something the court would approve on an emergency or ex parte basis. But other than that, generally, things move slowly at the court because of how many cases there are, and there may be a small time you'd have to wait.
Okay. So in that meanwhile, let's just say a child has an IEP meeting, and so they're 18, they need to sign their own IEP. And is there anything that you can recommend for parents that find themselves in that position if it is that the child needs to sign some documents, let's say, while they're waiting?
While they're waiting and they clearly don't know what it is that they're signing, mm-hmm. that's really tricky. I mean, the parent, if the child's 18, the parent wouldn't really have legal authority. So it depends on if it's legally required that the child sign, then, and if the child doesn't understand it, I think it might be stuck. Maybe there's some flexibility where the parent can sign if a caregiver or whoever needs to see this can be shown evidence that there's a conservatorship in the works. It's either been filed or something like that. But maybe a temporary conservatorship can be filed. But other than that, I don't know of anything other than the power of attorney, if there's the mental capacity and the age of majority, or the conservatorship. Now, sometimes if you file for temporary conservatorship, you can get a sooner hearing date. Again, maybe there's not the emergency exigent circumstances, but maybe just, hey, we need temporary conservatorship. We need to do this and this for the the education plan, or this is why we need it. Can you give us a sooner hearing date? And sometimes the court will work with you.
That's good. That's good to know, just in case parents find themselves in that situation.
Right.
Are there any other tips or advice that you have for families that are going to be beginning this process of limited conservatorship?
Let's see here. I was preparing for something different when you said tips. I was thinking more. Anyway, that's okay. I would say don't wait. If you don't have the means to hire an attorney, that's okay. There is a group within the court that helps legal aid sort of group, where there's conservatorship clinic. That's the word I was looking for. They give assistance there isn't a lawyer, but there's someone that talks to parents through filing the forms. Again, if money's of concern, there is a fee waiver. All of these documents are available on the court's website, www.sdcourt.ca.gov. All the forms are on there under the probate tab, as is the fee waiver. And generally, those fee waivers are approved if the child doesn't have resources of their own, which generally a lot of children don't. So that would be my best advice, would be either hire an attorney if you can afford it, and if not, use the conservatorship clinic and the self-help on the website to file these documents.
Awesome. And if we often have families who are listening or watching from other parts of the country. Is there any information, or are there maybe U.S.-based websites that they could get some assistance, or maybe their local state's website? It could be.
Yeah, to my knowledge, each county would have its own website, its own court website with the probate tab. I've dealt with other counties in California, and they're all pretty helpful. Most have a self-help section, and many have some sort of clinic where they can assist people that need it that can't afford a lawyer, and most have fee waivers. As far as other states, I can't speak to, because I haven't really dealt with it. I'm California specific.
But good to know that potentially parents might be able to investigate some of these same resources where they are as well.
Sure.
Another question is, can you tell us, I know there is some client privilege, but if you could maybe just share a little bit about a success story, or what might be a success story in families that you've worked with.
Absolutely. And something just a great pride of mine, actually. I just had a daughter in December.
Congratulations.
And, thank you. Her name's Mercy, and she's fantastic. That's part of the pride. But the other part of the pride was, when I said that I have a better relationship with my clients, and my daughter was receiving gifts from my clients. I have, I get Christmas cards from clients, and it just, in general, it goes back to, my dad being a criminal lawyer and him dealing with people that may or may not have perpetrated crimes. That's who he handled, their business on the day-to-day. I deal with families, wonderful people who I've become friends with, and who, care about me now and care about my life as I care about theirs. So I would say generally, I didn't really name a specific, matter, but getting gifts and cards and just building lifelong relationships with my clients has been my greatest reward. And I'm very proud of it. Other attorneys do other areas of law where they potentially make more money, have shiny things, but I wouldn't trade it.
That's beautiful. And in any profession where you can really add value, to the life of someone and even their children, I think is just very rewarding. I know I feel the same way. So that's awesome that your clients have made that connection with you.
My daughter's favorite toy is a Minnie Mouse, and it came from one of my clients. So.
Awesome. So we have some parents who are watching. Kanika, she's very glad that she was able to catch this. Actually, no, Kanika, she's in the process right now in conservatorship. So I know that there are many parents who are parenting teens with autism, on the autism spectrum, and various unique needs. And so this is a really good topic to help parents prepare for what the future holds. And I love the idea that you mentioned about potentially having to have conservative a moment for child's life, but at some point then being able to take that on individually. That's awesome. That's awesome. That's something really for us to think about and be hopeful about.
Absolutely.
Yeah. So, Thomas, if parents have more questions for you, how is it that they can contact you?
Let's see. One of several ways. My email address should be posted there, but if it's not, my email address is Thomas, THOMAS, at murraylawsd.com, MURRAYLAWSD.com. Oh, there it is. Yep. And then come to our local networking group if you're in the Grantville Allied Gardens area when we get back. Well, we're meeting the second Friday, right?
Yes.
We're virtual now, but hopefully back at Brothers Restaurant. Very proud to be in that group, and it's one of the reasons, honestly, that I targeted this area to where to live with my family. Is that just the sense of community I got from that group that I really didn't have where I had lived previously in San Diego. So it's a great group.
Yeah, we're so glad to have you. And as we are parting here, we have a parent question. How early can we prepare or contact the attorney, and approximately the fees? And I know we talked a little bit about that earlier. You said, best case scenario, age 17 would be the age, right, to start the process. And I can imagine, the fees may vary depending on the case and maybe the types of powers, I guess.
Yes. However, I can offer some insight. You're probably going to pay a little more money if you go with one of the bigger firms where there's many attorneys and many paralegals, and there's advantages to that. There's many people working on one case. Mm-hmm. And then you have newer attorneys who don't have as much of a client base and can afford to do things on a smaller scale. I think you can expect an hourly rate varying in areas, this area of law, this area of law being conservatorships, trusts and probate. I would say the general range would be $200 an hour, all the way up to the most experienced attorneys where it's in the neighborhood of $500 an hour. But when you have a petition for limited conservatorship, which is mostly what we've been speaking of, attorneys generally understand how long these take because it's the same documents, it's the same information gathering, and then if things are done properly, it's the first hearing where the court's ordering the authority you're asking for. So you could find attorneys that will do this on a flat rate basis instead of hourly basis. Okay. And I like to do that because clients are more at ease when they know exactly what it's going to cost rather than hearing that timer go off. Every time they make a phone call, you're being charged. Yes. Every time you send an email, it's going to cost you 0.3 hours at $300 an hour. So anyway, to answer your question, I think the range you can expect is anywhere from maybe $1,250 to $1,500 on the lower end, to maybe $3,000 on the higher end, $3,500 for a petition for limited conservatorship, and that's, like I said, all the information gathering, filling out. There's quite a few documents that need to be filed, and then there's a filing fee of $435 for really any new probate petition, so you have to worry about that unless you can do the fee waiver. So hopefully that helps and answers your question.
Yes, definitely. Yeah. And another question we have from Kanika, typically how long is the process?
Okay, good question. Depending on how quickly the information is back to the attorney, let's just say it took a week to gather the information, fill out the documents, probably a week or two. Then you file the documents. San Diego Probate Court, which is where these are heard, has now mandated that if an attorney is responsible for this case, it must be e-filed. So there's no more attorneys walking the documents into the courtroom or the filing room. I don't believe the same standard limits individuals who are representing themselves. I believe you can still walk it in there, but I just wanted to point that out. So let's say we e-filed the documents today. We would be given a hearing date ranging from probably 2 months to 3 months on a general, run-of-the-mill limited conservatorship petition. So from the day of filing, probably 2 to 3 months, maybe sometimes 4 if judges are taking holidays or the court's impacted. But at that first hearing, as long as the court appointed or the regional center report is in, notice has been done properly, and all questions that the court had were answered, I would say you should be able to get these within 4 or 5 months.
Okay. All right. Good. So that's where it comes from your first recommendation which is at minimum 6 months before a child turns 18, if not a year.
Right.
Yeah.
Right. Exactly.
So, Thomas, this has been wonderful information. Again, limited conservatorship, what every special needs family should know. One thing they should know is to not wait until that age of majority, not wait until 18. But a year, maybe, let's just say, might be a good place to start considering the process, looking for your attorney, someone as wonderful as Thomas Murray here, who can help you through that process. And then also parents considering what areas or powers that you might need for your child. Do you feel confident that your child can make decisions about their, health? I believe it was about their education, about where they live. If not, then those might be some of the main powers I believe you mentioned that parents can obtain for their child.
Right.
All right. And so parents, if you have more questions, feel free to reach out to Thomas. If you have more questions about the IEP process and adulthood transitioning and preparing the IEP for when your child leaves school, either with a high school diploma or during the transition program, feel free to reach out to me at San Diego SDAutismHelp.com, Sanford Autism Consulting. It's been another wonderful episode. So glad to have you here. Thank you so much, Thomas.
Thank you so much for having me. And I do like being called wonderful.
Oh, you are. And so I'm glad to make your day.
All right. Thank you all for listening. And please email me with questions. I'll be happy to help.
Awesome. Parents, always remember, you're going to be okay. And your child's going to be okay too. Have a great one.
Bye-bye.